resuming, maybe seated.
Your Honor, before we broke, you had asked a question in response to Mr. Schachter standing on the question of a determination about whether the First Nations were part of the proceedings as between Canada and Ontario. You'd asked for a clarification on that point.
Mhm.
And just to clarify, Ontario is not taking any different position than it did in phase one about the plaintiff's ability to bring the suit, but we are relying on Canada's representations in terms of the settlement reached in 1900.
Ontario is not taking any different position it did in phase one about their ability to bring this suit.
The plaintiff's ability to bring the suit and the determination that you made about the First Nations not participating in the proceeding.
In the arbitrations.
That's right.
Okay.
But we are relying on, Ontario is relying on Canada's representations made for the purpose of the settlement that the parties reached.
Right, but that didn't have that. That's not in any way relevant to the questions that were just on before we broke, right?
That was as I understood Mr. Schachter standing, that was the concern he was expressing.
And then I asked a question.
Yes.
Do you remember what it was?
To be sure we're on the same page, I wouldn't mind if you would restate it.
I asked whether it was your intention. I'll just go back to it. Whether you were intending to develop with this witness an argument that Canada was acting on behalf of the First Nations.
Yes.
You are.
Yes.
So the objection was with respect to that point. That was a matter already decided.
Well, we see it a bit differently, Your Honor. We see that the representations made by Canada in the context of proceedings vis-a-vis Ontario were binding by it in the settlement with Ontario.
Say that again, please.
The representations that Canada made in the context of the arbitrations with the provinces was binding on Canada.
And those representations were?
That it was representing the First Nations in the context of that proceeding.
Mr. Schachter?
I'm not sure what to make of that response. If my friend is trying to say, yes, we accept the matter of res judicata, that Canada was not acting on behalf of the First Nations, that's it, full stop. Whatever they want to argue in terms of vis-a-vis what factors the court takes into account in determining the respective liabilities as between Ontario and Canada is a separate issue, I suppose, but the fundamental issue that is res judicata is, as I understand it, is the Canada was not acting on behalf of the First Nations, and the First Nations were not a party. And I don't have the judgment in front of me, but I'm pretty certain it's there.
And so maybe an easier way to approach this is, with respect to my question, is with respect to the issue as between Canada and the plaintiffs. Are you intending to develop a theme through this witness that Canada was representing the First Nations? Hopefully, as I understood your answer, you don't step away from the argument you make vis-a-vis your position in response to Ontario, or your position against Canada, as between you two, as between the crowns.
Yes.
But you are not intending, if that yes is what I think it means, mind if you elaborate, that you are not attempting to take a position or develop the evidence through this witness on a position with respect to the plaintiffs.
That's right. And this is consistent with what we've said in our opening statement as well. There's nothing new here in terms of Ontario's position.
It's been some time. You'll have to
I
forgive
understand.
me. All right. Is there anyone from Canada here? Is anybody? Oh, good day. You have anything to contribute or add? Mr. Schachter?
Yeah, I do have, I mean, what is res judicata is res judicata, and that's, and how it affects the remaining issues. I guess my friends can argue, but they're not, we will stand up in argument and say that the matter is res judicata. And as for, as for relevancy, I have some concerns that we're going into an area that's irrelevant, given the matter of res judicata, but perhaps I don't want to intrude in my client's case, my client, my friend's case. I don't want to intrude in their case. They have a case to make. I don't quite understand it, how it could possibly, how they can relitigate the very issue that is res judicata. If they're not doing that, I don't know why the evidence is otherwise relevant, but perhaps they can persuade the court that it is. And that's all I have to say, unless there's any questions.
Thank you. I'm scratching my head on this, Ms. Glasser. I don't want to take too much more time on it. You're on notice that you will face a strong argument on res judicata. So it's one thing to say, we're not changing our position from stage one, but a lot has happened since stage one.
Understood.
And if you ignore it, it's not necessarily the most respectful position in front of the
I
court.
understand.
All right, let's go.
Before the break, we had been looking at the November 28th, 1890 memo concerning the second arbitration process, and that was at JB 2602. We don't need to pull that up again.
So when you're saying the numbers.
JBD 2602.
Thank you.
And I wanted to go now to, we're still on slide 74. I wanted to go to tab 2570 of the JBD. And this is at tab 95, in the compendium of documents to the demonstratives.
And when you say tab 2570, is this something that's otherwise been described as exhibit 1-2570?
For the, yes,
Thank you.
the JBD is an exhibit.
And you're now always talking about in this trial.
Phase,
3.
yes.
Thank you.
I'll try to be mindful and say otherwise.
Thank you.
Ms. Jones, can you refresh our memory about the memo and the relation of this document to that memo?
Now the memorandum 1890, are you talking
Yes.
about? Oh, 1890. This is after the meeting of November 1890. There was an agreement among the parties that there should be another arbitration process regarding the settlement of accounts, this time including the Dominion of Canada, as well as the provinces of Ontario and Quebec, and between the said provinces. So in other words, this is now both bilateral and tripartite determination.
And we describe this document as an act respecting the settlement of accounts dated July 1891.
Yes,
And this is Canada's legislation, I believe,
yes.
Thank you.
as there will be legislation
And
with
if,
other parties.
unless there's some distinction between Ms. Jones and Professor Messamore on this evidence, we have gone through those acts. You will have seen that.
That's true. So I'm highlighting here, Ms. Jones, if you wouldn't mind, what is that issue? What is being reflected in this statute in terms of the matters that will be determined through the arbitration?
All right, so if you can scroll down just a little. This is in respect of the accounts, the settlement of accounts in the Dominion of Canada, the provinces of Ontario and Quebec, both jointly and severally. And the intent of the legislation, as in paragraph 1, is for the final and conclusive determination of such accounts. And this is the enabling legislation to appoint an arbitrator by Canada. It indicates that there will be, the arbitrators will be 3 judges, one to be appointed by each government, but that the arbitrators shall not assume to decide any disputed constitutional question. So they are focusing on settlement of accounts.
And from your point of view, did this statute reflect what had been set out in the memo we looked at before the break?
Yes, I think so.
If we can go to slide 75 with the demonstratives.
This is the mechanism, the appointment of the 3 arbitrators and who they were. Mr. Burbidge, Judge of the Exchequer Court, Mr. Boyd, Chancellor Boyd, Head of the High Court of Justice of Ontario, and Mr. Casso, the Senior Counsel to Quebec in the arbitration hearings of 1869 and 1870. There is some backstory as well to Mr. Burbidge and Mr. Boyd. Burbidge had been a Deputy Minister of Justice for Canada, and Mr. Boyd is known, among other things, for a decision called St. Catherine's Milling, which had been decided previously on Indigenous rights and provincial and federal jurisdiction over surrendered land. It's just a little bit of a backstory on them. What is going on already by the time these people are being appointed is the process of collecting and preparing the financial data on the Robinson Treaty territories. Ontario at this time is preparing extensive reports assessing the eligibility of Robinson Treaty beneficiaries. These reports, which were completed in 1891 and 1892, advised Ontario that Canada was paying annuity to many people who were not, quote, legally entitled, end quote. And this was, in these reports, was estimated to be a large proportion of the people that were currently receiving the Robinson Treaty annuity. So those reports were not shared with Canada. This is advice to Ontario coming from Mr. Boren, actually, who had been had put forward the claims of Robinson Treaty beneficiaries to an increased annuity and to arrears. And it should be noted that he continued to support those claims. The focus of his inquiry was the number of people who were being paid annuity, many of whom, as I've said, he did not believe were legally entitled.
If we go to slide 76, please.
The first meeting of the arbitrators was on 17th of March, 1893. And this point in time, it was decided that council should reach some agreement on what was to be submitted to the arbitrators. So this was incorporated in a document of April 1893, endorsed by Council for Canada, Ontario, and Quebec, called the First Agreement of Submission.
I'm gonna pull that up if you don't mind, Ms. Jones. That's at tab JBD tab 2631. And the compendium for the demonstratives tab 96.
There it is, the first agreement of submission.
And can we call this Canada's submission?
It's endorsed by council for all three parties.
Thank you.
It's not clear who had the most drafting of it. It seems to have been a document that was developed by all three of them.
Thank you.
So if you can scroll down a little. This is the agreement on what will be submitted to the arbitrators. All questions relating to or incident to the accounts between the Dominion and the provinces of Ontario and Quebec, and between the two provinces of Ontario and Quebec. At this point, it's the accounts as rendered by the Dominion to the provinces up to January 1889. This is later brought forward to the end of December 1892. The rate of interest was a topic of much discussion between the parties. The accounts as rendered by the Dominion, and then also the claims made by the Dominion government on behalf of Indians and payments made by the government to Indians. Now, this is 2631. Just go down here. Right. There's the signatures of the council for all three parties. And in the last paragraph, it says it is further agreed that nothing herein contained is to limit or preclude the parties to this reference submitting such further and other questions or matters to the said arbitrators as may be mutually agreed upon. So they have a start, they have a shopping list, but it's agreed that if all parties consent, they could also submit other matters to the arbitrators.
And this first agreement of submissions, it did in your next bullet get reflected in an order in council?
Yes.
And for reference, Your Honor, that's at your tab 97 of the compendium of demonstratives.
When we go through these slides, I do not need to see every background document,
Sure.
particularly if we have already seen them. So we can just take us through the slides. If there's something you would like to point out that is different, particularly when it's evidence that we have just heard, and I'm sure you're familiar with it.
Yes, I can't profess to know every single document that was referred to before, but I take. your
No,
point.
it's the points,
I understood.
themes.
Yes.
Thank you.
We're over at slide 77 now.
So as part of this preparation process for the arbitrations, in May of 1893, Council for Ontario, which is Mr. Emilius Irving, he is an outside counsel, by the way, just in case there's any confusion about that, sent the Deputy Minister of Justice for Canada a package of financial statements showing expenditures and receipts in the Robinson Treaty Territories. And these cover only a couple of departments. They're not purported to be complete statements by any means. For the departments covered, they seem to show overall revenues exceeded expenditures for those departments. So this information then made its way over to the Department of Indian Affairs. And the next month, the Deputy Superintendent General of Indian Affairs, Mr. Van Koenet, writes to the Deputy Minister of Justice for Canada, pointing to the immense revenue from the sales of land and timber within the territory ceded and suggesting that the amount of annuity might fairly be increased to such further sum as Her Majesty might be pleased to order. In other words, what Van Cunit is saying in this letter is that we shouldn't be looking at just $4. We should be looking at a larger amount of money based on what he calls the immense revenues from the sale of land and timber within the territory ceded. And he wishes to draw the attention of the Deputy Minister of Justice to this clause in the treaty to point out it is not just $4 we're talking about. It is an additional amount as yet undetermined.
Please remind me who Van Cunit is.
He is the Deputy Superintendent General of Indian Affairs.
Federal, sorry, Dominion?
Canada, yes,
Thank you.
Dominion, yeah. And very shortly thereafter, Mr. Newcomb replies to Van Cunit to say, the point will be not lost sight of, though it is very questionable whether the provision in these treaties can be made the basis of any legal claim against the province of Canada. So you note here that Newcomb is not saying that the claim has no merit, that there is no enforceability to that part of the treaty. He is only saying he is doubtful whether that claim it can be made the basis of any legal claim against the province of Canada. We don't know what his reasoning is. If there are files in the Department of Justice, files like this are usually considered to be still subject to solicitor-client privilege. So I haven't been able to locate any discussion internal to the Department of Justice as to what factors they considered or why they offered this particular advice.
In the normal practice, if there were documents being withheld from your request because privilege was being claimed, would you be advised of that?
Yes.
So were you advised that there were documents being withheld? But privilege could be claimed?
The lists of files to which I had access from the Department of Justice, I couldn't see on any of those lists of files. I have groups of subject headings, but in some cases I don't have lists of files. It's also possible that this file, if there was one, doesn't exist any longer. You know, if that is another possibility. But
Never existed, doesn't exist, or somebody's claiming
is
privilege.
subject to privilege.
But
Yeah,
nobody has told you they're claiming privilege.
that's correct.
Okay, thank you.
But in any event, I can make a general observation that much of this kind of information is still considered to be subject to privilege as to how legal opinions were developed. So all we have is, this is a very brief letter. We only have Newcomb's advice to the Department of Indian Affairs. He is doubtful, although he says he's not lost sight of the point of the additional sums over $4. He says he's not lost sight of that, but he is doubtful as to whether that provision could be made the basis of a legal claim against the province of Canada, without offering a particular opinion as to whether or not it's enforceable in any other way. In October of 1893, Mr. Van Cunit was superannuated from the civil service against his wish and replaced by another man named Hayter Reed. I've been asked whether I thought that this opinion of Van Cunit regarding the clause over and above $4 contributed to his superannuation. And I haven't seen any evidence that that's the case. The department, of course, was dealing with many, many issues besides this one. It does appear that the previous Minister for Superintendent General of Indian Affairs wanted Van Cunit to be superannuated. And when his successor, the previous Superintendent General, came into office, apparently he wrote a private letter to his successor to say, now's your opportunity to get rid of this guy. So I think there were other things going on that we may not be completely conversant with. But the fact is, what we do know is that shortly thereafter, Mr. Van Cunit was superannuated.
Which for the uninitiated might mean terminated from his employment.
Yes.
Slide 78.
Now we have the descriptions of the cases filed with the arbitrators, just what arguments were put forward. Canada claims against the province of Canada for arrears between 1851 and 1867, against the province of Ontario for arrears between 1868 and 1874, and against the province of Ontario the amount of annuities actually paid by Canada between 1875 and 1892, with a credit for the fixed annuities, the interest on the capitalized fixed annuities. So you'll see what the distinction here is. The amount of annuities actually paid by Canada, because those were per capita payments, the amount would fluctuate. It would be different from year to year. Whereas before per capita payments, there is a calculation of the difference, but it's what am I trying to say here? It might be a more limited payment. There was some attempt by the department to determine how many people might have been entitled, but as we see later, there were complications with those calculations. And as well, they claim 5% interest on all of the amounts that they claimed per year. So just in terms of what Canada was actually doing in 1892, the annuities paid by Canada in 1892 require a legislative grant of $16,806 to make up the difference between the $4,400 they have from the capitalized amount and $4 payments to every person they're paying on the Robinson pay lists. So that's the amount of money that they're claiming. The basis that on which Canada based its argument was that Ontario had received Robinson Treaty lands at confederations subject to a trust and an interest under Section 109 of the BNA Act, and that Ontario as the beneficial owner and the recipient of the revenues was legally liable to provide the Dominion with monies necessary to pay the annuities. Those are Canada's arguments.
Slide 79.
The parties here are still exchanging factual or at least data type information, as well as making their arguments. In December of 1893, Canada sends to Ontario a statement of revenues and expenditures in the Robinson Treaty territories between 1851 and 1867 from records held by Canada. And those would include records on customs, Indian Affairs expenditures, and some of the public works that had been assigned to the Dominion at Confederation. And again, these statements generally show an excess of revenue over expenditure. Ontario then provides more statements, bringing forward revenue and expenditure information within its control up to the end of 1892. In June of 1894, you can see there's long intervals here, which is, I think, partly reflective of the amount of data that's being compiled and the exchange of this information. June of 1894, Ontario files its answer to the case of Canada. Ontario's argument was the liability was that of the province of Canada and should have been absorbed in the increase of the debt allowance of 1873. There was no trust on the land ceded, and the lands had never produced enough revenue to pay the augmentation without loss. And also a big part of Ontario's argument was that Canada had paid annuities to persons who were not entitled and requested a comprehensive accounting of all of the expenditures and revenues in the territories.
Slide 80.
So just to, excuse me. Excuse me. So just to confirm, they're exchanging financial information.
Right.
And in bullet 1 on slide 79, Canada, the Dominion, is pointing to statements that, in the words of the bullet, generally show an excess of revenues over expenditure
That's right.
for the territories. And in that same document exchange, perhaps documents being prepared by the different crowns, Ontario takes the position that the lands never produced enough revenue to pay the augmentation
Right.
without loss.
At this time,
Sorry, is this the first time that that difference has been expressed as between the parties that you recollect?
I think that is new in 1894 because in the 1870s, Ontario apparently conceded that the revenues exceeded the expenditures sufficient to pay the increased annuities.
Right, that's what I recalled. And in the meantime, do you recall anything else as between the parties on that topic or on that, whether there was agreement or disagreement?
I think on this particular issue of expenditures and revenues, there may have been some general discussion, but it was, there's definitely a gap in the data. And among other things, the parties have not yet agreed on what classes of expenditures and revenues will be allowable in this calculation. Even how many people should be paid and to what extent. So while these statements are being exchanged, there's really no common ground on what's relevant to the conversation.
They haven't agreed on they don't have a common data set.
Yes.
Okay, thank you. Go ahead.
Now
We're on-
this,
sorry, just to make sure the record reflects, we're on slide 80.
slide 80. So this is the mirror to, I think it is slide 72. Again, I think it's important to express here that this is the perception of the parties, or at least the expressed perception of the parties at this time. Whether or not this is legally accurate or enforceable or relevant or anything else is not something on which I would be expressing an opinion. I'm only producing material like this as a way of trying to get some insight as to why the parties acted the way they did at the time. Whether or not it was defensible or correct or anything else. This is about perception rather than a determination on responsibility or anything else. The question of representation of Indigenous people who were Robinson Treaty beneficiaries was raised before the arbitrators in 1894.
Sorry, Ms. Jones, I just want to have the document up that you're citing here, which is JB tab 2635 and tab 106 of the compendium of documents for the demonstratives. We'll be going to image 471 on the screen in the courtroom, but page 2 in the demonstratives, tab 106.
Right. Now, to introduce Mr. Robinson, who is counsel for Canada at this time, again, outside counsel. He is the nephew of William Beverly Robinson, the person who signed these treaties. And he has several interesting observations, which I think I brought out in my phase 1 report about the treaty signed by his uncle. He's also a witness to the award of 1870. He has signed as a witness to that award. So now, by now, he's very senior counsel.
Introduce the document or just give us a name for the document before you tell us about the parties, actors.
This is the transcript of the arbitration proceedings in November of 1894. The proceedings on, they call it Indian Claims Robinson Treaties.
Thank you. Go ahead.
The Chancellor, Mr. Boyd, raises the issue in the among the parties as Mr. Robinson is speaking. Chancellor Boyd says to Mr. Robinson, the Indians ought to be a party.
What page, please?
It would be page 2 of your compendium, Your Honor. And on the screen in the courtroom, it's image 1042.
So it's the second page of the tab.
Yes.
Thank you.
Mr. Robinson replies, so they are. In other words, he's saying, yes, the Indians are a party. The Chancellor presses him. They have more interest in pressing this claim than the Dominion. So Mr. Robinson replies, they are parties through us, I suppose.
Some judges let that happen, I suppose.
And the Chancellor continues to press him, saying, yes, as representing the Sestuka Trust, that is quite so, but the rule is that where the trust is sought to be diminished, then the Sestuka Trust ought to be represented. But then he changes direction a little and says, but of course, the Indians are protected just as well as they can be by you, because they could only be represented by some other council. In other words, he's saying, well, the Indians would have to have lawyers anyway. So I suppose you, Canada, lawyers, could be those people. And Robinson replies by saying, we are appearing here, the Dominion, on behalf of the Indians. What I contend on behalf of the Indians is that every farthing due, a fair and reasonable construction of this treaty should be paid to the Indians. I contend for nothing more. If I am able to say to any Indian, we have presented your claim fairly, and they, meaning the arbitrators, think you are not entitled, we have discharged our obligation. What interest can we take beyond that?
You can go back to the slide deck. Slide 81.
And this seems to be accepted by the arbitrators, this statement. They don't press him any, they don't press Robinson any further.
We're on slide 81.
So again, Canada's argument, according to these transcripts, was that now there are several arguments. I'm summarizing and I'm presenting the ones that I think are the most salient. Canada argues the annuities were to be paid out of the revenue from the ceded lands. Discussion ensues about the annuities were paid out of the revenues of the lands or whether sufficient revenue was simply a precondition to payment. That point was not really resolved in the transcript. And also it became apparent that Ontario and Canada could not agree on a list of categories of revenues and expenditures to be used in calculating whether a surplus had been received. Ontario then also argues that the maximum number of treaty beneficiaries had been set out in the treaty. Those are the numbers mentioned in the treaties. And that Canada was paying many people who were not entitled. And again, we in retrospect can go behind the curtain a little bit and be aware that Ontario is getting very strong advice from the magistrate who is investigating Robinson Treaty payments for them, that Canada is paying people that this magistrate believes would not be entitled under any legal definition. Just as a demonstration of how these reports, which run to hundreds of pages, were made, he had members of the Indigenous communities, say around Sault Ste. Marie, go and interview other people about their families and their connections to the treaty. And he used some of that information to make his own assessments as to whether or not he believed they were entitled. This is Mr. Boron. So Ontario is very insistent on this point. And it became clear that Canada, Ontario could not agree even on how to establish the essential facts of whether there was sufficient revenue to pay an increase, how the payment of annuities would factor into that surplus, and what categories should be considered, even how to establish the basic facts on which the arbitrators might be able to make a decision. So the arbitrators agreed to rule on an interim basis only on the issue of liability for the payments and not whether the condition to pay the increased annuities had been met or what was owed to the treaty beneficiaries.
So there were two matters left outstanding. Population, how to count it, and two, how to count revenue, how to determine whether the trigger had been met.
Right.
Ms. Jones, was there any representation following on from your last slide about responsibility for the augmentation clause of the treaty?
Yes, well, we've seen that there's there's no agreement on how to establish the facts. So we have a fact-free environment unfolding. And in terms of even trying to get towards a way of addressing those questions, there are exchanges at various points in the transcript on the specific issues that are outstanding in order to try to reach some common factual basis. And so, for example, there's an exchange with the Solicitor General of Canada, which who was representing Canada as part of its legal team in front of the arbitrations. That has to do with the amounts that might be payable under this treaty.
You've identified JB 2635 on that slide.
Right,
That's the transcript document you referred to on the previous page.
yes.
Okay, Your Honor, if I may, we have some extracts from the transcript that we wanted to hand up for the benefit of yourself and the witness to read from. We don't have it in the compendium demonstratives that we handed up to you.
All right, do we need them?
Yeah, I might say, of course, these transcripts run to hundreds of pages, so I have quoted some things in my report. I have an even smaller selection on the slides. There are many things in the transcript which I haven't referred to directly, but of course I did review the entire transcript.
So I've handed up a document, which is the extract from the transcript. And you were just telling us about the exchange with the Solicitor General for Canada. Can you identify that in the document in front of you?
Yes. Now, is this up on the screen or do we just have it in the?
You do,
Hard
yes,
copy.
what's in your hand is on the screen also.
Okay, good. So I think if you go up a little,
If you could identify the document. first.
yes.
Thank you.
Now, so this is again, this is another part of the same transcript from November 1894, the hearings before the arbitrators. This happens to be page 63 of that transcript. Mr. Curran is reviewing some case law regarding treaties and noting that the treaties were made with, as he calls them, the tribes under the authority of the sovereign. The faith of the nation was pledged in dealing with those annuities. He talks about the special relationship towards the Indians. And then a question arises about whether or not Canada could increase the annuities without notice to the provinces. Again, if you recall, in 1869, Ontario and Quebec had requested that nothing be added to the debt of the province of Canada or to their debts separately without their consent. He says the province of Ontario is specially concerned therein, meaning the increases, and I think is bound in honor and every other way legally by the proceedings that then took place. This is around 1874. So he's now talking about the reliance of Canada on the information from Ontario that the revenues had reached a point at which increased payments could be made. But then Mr. Burbidge, one of the arbitrators, asks Curran a question. He says, if the Dominion increased them, meaning the annuities, they, the Dominion, increased them, the annuities, at their risk. If the provinces were liable, they would be liable for the increase. And if not, the Dominion would have to assume it. The liability the Dominion succeeded to was a legal liability. Is not that it? And the Solicitor General replies, as regards anything further than $4, the consent of Her Majesty would be distinctly necessary under the provision of the treaty. Burbage presses him. He says, and you concede if the Dominion had increased it beyond $4 without the consent of Ontario and Quebec, the Dominion would have to pay for their own graciousness, again, referring back to that clause in the treaty. The Solicitor General Curran replies, yes, there is no doubt about that. In other words, the Dominion's view at this time was that if they can't get the consent of Ontario and Quebec, they may have to pay for the exercise of this graciousness clause. Again, I'm thinking now of Newcomb's legal advice to say that the claim for anything beyond $4, in Newcomb's opinion, is doubtful against the provinces of Ontario and Quebec. And I'm wondering if this is behind Curran's statement here, that he has legal advice from his deputy, again, that we're not privy to all the details in the reasoning. But
Did Newcomb refer to legal advice, or we're just presuming he has it?
well, to me, that letter to the Department of Indian Affairs is an expression of his opinion
Yes,
as to whether this claim can be pressed against Ontario and Quebec.
right.
Not the overall validity of it.
No,
But
so
whether it
when you
can
say
be-
legal opinion, his legal opinion or someone to Newcomb?
Could be either.
I just wondered what you were referring to.
It's,
You said something about Newcomb's legal advice,
yes.
I thought.
So when he wrote to the Department of Indian Affairs as the Deputy Minister of Justice,
Yes,
I think he is offering the opinion of the Department of Justice as to whether or not this can be made a claim against Ontario and Quebec.
Ms. Jones, is that slide 77 that you're referring to with the exchange with Van Kunet?
Yes.
So we can go to slide 82 then. And as Her Honor indicated earlier, there's some aspects of the evidence that we have heard. And if you could just go briefly over your slide 82, that would be appreciated.
Right. Well, this is the third award, which we've all seen more than once. Oh, no, this is 82 we're looking at. Yes. So again, the arbitrators here can't make an award on anything except for the liability argument because they have no facts that are agreed on. So the third award is restricted only to the issue of who pays and also how many, because Ontario had been saying that the payments have to be restricted to the numbers given in the actual treaty document. They do go a little further, the arbitrators, by saying that the tribes were entitled to such increase, not exceeding $4 for each individual. So that is an expression of a opinion, perhaps outside some of the arguments that we have just reviewed. But that the total amount of annuity is to be ascertained by paying everybody. Everybody who's presently being paid. And also they give some direction on how the excess is to be calculated. In any given year may not be used to give the increase in a former year, but any excess can be carried forward.
Turn to slide 83.
And section 4 indicates that the increased annuity was a debt which devolved upon Canada under the 111th section. And that under the 112th section, it is part of what the arbitrators call the excess of debt, for which Ontario and Quebec are conjointly liable. Not to say that this particular item is part of the excess of debt, but that it's to be taken into account in calculating what that number is. The ceded territory became the property of Ontario under the 109th section, subject to a trust to pay the increased annuity. And that the ultimate burden of making provision for the payment of the increased annuity falls upon the province of Ontario.
Slide 84.
Section 9 of the award states that the increased annuities which have been paid by the Dominion, so these are the ones that have already been paid since the Union, since 1867. Any payments properly paid are to be charged against the province of Ontario. The arbitrators did declare that they had proceeded upon their view of disputed questions of law. So very promptly, Ontario files a notice of appeal of sections 6 and 9 to the Supreme Court of Canada.
Over to slide 85, please.
Just a quick overview of the arguments before the Supreme Court. Ontario's arguments included that the Robinson Treaty lands passed to Ontario in 1867 without any Indian trust or interest. Sections 13 of the award of 1870, the one to do with Indian lands of the provinces, did not contravene section 109 of the BNA Act. Ontario argues that section 111 of the BNA Act put the primary liability for the annuities on Canada, and that the annuities were not a debt within section 112. And in the alternative, if the liability were found to be within section 112, then it was to be borne by Ontario and Quebec jointly, not Ontario alone. And in its oral arguments, Ontario referred to the treaty commitment to pay all of the annuities as being based on the honor of the crown, not a charge on the land.
Turn to slide 86.
So Canada, in reply, argues that the lands did pass to Ontario at Confederation with a trust under 109. The increased annuities should be paid from the revenues of the land when it was possible to do so without incurring loss. Canada quoted Chancellor Boyd's reasons for the third award. The mere words used do not say that the increased annuity is to be paid out of the proceeds of the land, but that is the plain and reasonable implications. And that the Indians would be entitled to look upon such surplus as being held in trust for them by the government. And that Ontario had received the full benefit of the lands and should have provided and continued to provide Canada with the money to pay increased annuities. So they're not talking here about Ontario making direct payments. Canada will still make payments, but Ontario should recoup them for increased annuities. And Canada also makes some arguments about capitalization and about the award of 1870.
Slide 87.
Then there's a judgment of the Supreme Court under which the court reversed sections 6 and 9 of the award. This incredibly awkward wording. The provision in the treaties as to increased annuity had not the effect of burdening the lands with a trust under 109. And that the increased annuities both before and after Confederation were chargeable to the province of Canada. So bear in mind, I just wanted to recall what else is going on here. The province of Canada debt is still being ascertained under the second arbitration process. And Ontario and Quebec are still going to be liable to pay 5% to Canada on any excess over the limit set in 1873 in the proportions as set by the award of September 1870.
Can you help us understand why that was relevant to you to note that here?
Well, we've gone a fair distance towards discussing the arguments being made about the specific implementation of the Robinson treaties. And I just thought it would be helpful at this point to recall what process is underway while the specific arguments and decisions are being made about the Robinson treaties in particular. This is about the arbitration process is about debt and it's about accounts. That's the focus of what the arbitration is supposed to be doing. So these arguments and court rulings that are in process are focused on how that debt is going to be allocated and how it's going to be calculated.
Slide 88.
So this was appealed to the Judicial Committee of the Privy Council in 1896. And the legal counsel representing Canada in London reported to Newcomb, still Deputy Minister of Justice, that the only question on this appeal was the true construction of Section 109. That the only thing they ruled on was the sole liability of Ontario. They did not really address the question of whether it could be a conjoint liability. That's what the decision was narrowed to.
That was the position of counsel for Canada.
Yes, after attending the hearing, he said, this is what the Judicial Committee talked about. This is the only issue in which they were interested, was just 109, not the conjoint liability or anything to do with the treaty in particular.
Slide 89, please.
This is reflected at least in part in the JCPC decision that said the main and only question between the parties is whether the liability for the increased amount of the Indian annuities is so connected with or attached to the surrendered territory under 109 as to follow the beneficial interest and to form a charge upon it. The judgment of the Supreme Court of Canada was upheld. The Judicial Committee said it must still be a matter of absolute indifference to the Indians, whether they have to look for payment to the Dominion or to Ontario. The Judicial Committee describes the promises in the treaty as a promise, an agreement, a personal obligation by the governor as representing the old province that the latter should pay the annuities. And that under the treaty, the Indians obtained no right which gave them any interest in the territory they surrendered, other than that of the province. And no duty was imposed upon the province to apply the revenue in payment of the annuities. So again, there's no decision here on whether the conditions for a payment have been met or any of the data points, which still have not been agreed on at the most basic level. This is strictly a decision that relates to if there is a payment owing or if there is a treaty obligation, to whose door does it fall?
Your Honor, if we could, I would like to take the afternoon break now, because we'll be going into another section and that will be the last before we end for the day.
And what's your thought on time? How long will that take?
We've been going much better in terms of timing than I anticipated. So if it's almost 3 now,
Mm-hmm. So if we come back at 3:15,
yeah, that's fine. And then
do you think you'll finish today?
not the examination in chief, but I think that we can, if we started at 9, I'm happy to finish, I'm guessing around 4:15, if that would be okay with the
Alright.
court.
So in terms of,
Is that tomorrow or today?
in terms of what you have left for today,
Yes.
how much do you think you have left of your examination in chief?
For today?
No,
Or in
total.
general? Oh, I would expect I would still have several more hours tomorrow.
All right. Very good. And so I'll let you talk at the break about start times. Yes, let's take a break then. Okay. I have
Members, you may be seated.
Your Honor, my plan is to finish no later than 4.
with how much time left? So then you'll start tomorrow
Yes,
and go.
I would expect it would be completed before the afternoon break. If not by lunch.
Very good. Thank you.
I should add that I understand Canada will not be ready to proceed with the cross-examination until Monday
Oh, that's
due
right.
to unavailability of counsel.
I
So
recall
we
now.
are not in a rush to finish on Friday, I would suggest, and we need to start early. On tomorrow, we don't have to start at 9,
Right. Nor did we have to today.
nor did we have to today.
Okay. Carry on.
Okay, we're on slide 90 of the demonstratives. And Ms. Jones, before the break, we had finished your review of slide 89, which was about the decision of the JCPC.
Correct.
And now we're on to award number 1, as you've referenced it in the title of the slide.
So while the Robinson Treaty issues were making their way through all the levels of appeal, the arbitrators were continuing to hear other issues. And I just wanted to draw attention to a couple of the rulings on those issues. What we call award number 1, or the first award of November 1893, was on the interest question. There was a dispute between Ontario, Quebec, and Canada as to whether the interest accruing on the provinces of Canada account and that any balances in favor of Ontario and Quebec should be compound or simple interest. The awards.
I'm just going to ask council, is this material relevant to any determination that has to be made?
In Ontario's view, it is
Tell me how.
the relevant interest rate that would be applied to any debt. As between the provinces and Canada.
Thank you.
The award specified that 5% simple interest was to accrue on the province of Canada account and any balances in favor of Ontario and Quebec. And the award also specified how some entries that we've already seen in the accounts as they were drawn up in 1900 were to be entered in the accounts. So those were the subject of an award. The award was appealed to the Supreme Court of Canada, where it was upheld in 1895. It was not appealed to the Judicial Committee, but it was very important to the parties at the time whether the interest was to be compound or simple. As you can understand, it would make a substantial difference in the amount of money that would be accruing on these accounts. In September of 1895, the arbitrators issue a ruling on the Act of 1873 or any subsequent agreements among governments. For example, there had been an agreement in 1888 among governments about some of the items on the accounts, some of the accounts. And the arbitrators ruled that the Act of 1873 or any subsequent agreement had not fixed the amount of the debt of the province of Canada or of any entries making up that amount. Each item in the account were stated by the arbitrators to be each and all of them examinable. The arguments of some of the parties in some of the other arbitral hearings were that there had been an agreement among ministers to set the value of certain items at a particular level, or that the Act of 1873 had fixed the amount of the debt. And in this ruling, it's not a separate award. It's a ruling of the Act of 1873 had not fixed the debt, and essentially that every item in the accounts up to that point was still open for argument and
Still
discussion.
outstanding.
Could be altered.
Slide 91.
So now, after the appeal to the Judicial Committee has been heard, and we have the ruling in 1896, the parties can go on with further arguments and arbitration on Robinson Treaty issues. This started in 1897. And again, I'm just going to summarize some of the arguments just to make it clear what was discussed before the arbitrators. This is not a comprehensive list of the issues by any means, but it's some of the more salient ones. Canada's case was that liability for the arrears of annuity from 1851 to 1867 had already been decided by the third award. And that between 1867 and 1875, quote, the Indians should have received the full increased annuity of $4 per capita. And that the amount of this increase, plus what had already been paid by the Dominion between 1875 and 1892, was a debt or liability of the province of Canada. Those Canada's main arguments. Ontario responds by again denying all liability for the increased annuities, either separately or conjointly with Quebec. Remember that the conjoint issue had not been decided by the JCPC. So that avenue was still open. And Ontario also denied that the net revenues from the territory were sufficient to pay an increase before 1875 or any more than a fractional increase after 1875. And again, we're at a state here where there has been no consensus on how to calculate this surplus of revenue.
It
So
was ever thus.
yeah. So, people are making arguments without any common agreed upon data between them. And in particular, Ontario asked Canada to prove the eligibility of beneficiaries paid annuity between 1850 and 1892. And again argued that the total number of beneficiaries was capped at the number stated in the treaties. And they also prepared a proposed list of categories of expenditures to be deducted from proposed list of revenues in the territory, and asked the arbitrators to provide direction on the allowable deductions and on the criteria for eligibility for annuity payments.
Slide 92.
While all this was going on, Ontario and Canada had been continuing to gather information to prepare for these hearings. Canada had begun its own investigations into eligibility of Indigenous persons receiving the Robinson Treaty annuity. With one of their own employees, a senior official named McRae, who began these detailed investigations of eligibility. He would go through, for example, the genealogies of the various families, how they came to be added to the treaty pay list and at what time. Now, a lot of the people whose eligibility was particularly under challenge were people who had been brought into the treaty pay lists through the female line. In other words, a woman who had been married, who had been on the pay list, if she had married someone who had not been on the pay list, and her husband and all of their descendants had then been paid treaty annuity. Under the Indian Act of 1876, those types of claims had been disallowed. In other words, women who married someone who was not already considered to be of Indian status would lose their Indian status, as well as all of their descendants would lose their Indian status. But when the Robinson Treaty was signed in 1850, there was no such restrictive definition legally of who was an Indian who was entitled to be a treaty beneficiary. And in fact, under the system where the fixed annuities were paid, the chiefs had a wide degree of latitude as to who they could decide to add to the treaty pay lists, because really Canada had no particular, as they say, skin in that game.
Because they had a fixed amount.
They had a fixed amount. So if a particular chief or a group of people wanted to add more people that they felt were part of their group, the only thing that would happen to them would be that the individual payments might go down. But to Canada, it didn't matter. After treaty payments became per capita, it mattered more because of the number of people paid would affect the total amount paid. But by that time, there were people who were on the Robinson Treaty pay lists who had been on the pay lists for 25 years with all of their descendants and all of their relatives. And there had been a body of custom had grown up around these pay lists, who was considered to be part of these communities according to the pay lists. And Canada was aware of the fact that not everyone on the pay lists might qualify under the 1876 Indian Act. But as far as the Robinson treaties were concerned, that wasn't really the criterion, because the pay lists for the Robinson treaties had been established long before the 1876 Indian Act. The Canada, nonetheless, began these investigations of eligibility of Indigenous persons. For example, they were interested also in people who might be considered American Indians who resided most of the time south of the Great Lakes, or people who had moved away for extended periods of time, people who were drawing benefits under another treaty, particularly the Manitoulin Island land surrender treaty. But the Department of Indian Affairs at this time informed their counsel, Mr. Hogg, Counsel for Canada, outside counsel, that in their words, no persons have ever been paid annuity money under the Robinson Treaty except those who were believed to be bona fide Indians. The Superintendent General of Indian Affairs is and always has been the sole authority to decide who are Indians. But they were, as I say, they were aware that some people who had been recognized as Indians under the Robinson treaties would not have been eligible under later legislation in 1876. But at the time these investigations were taking place, there's kind of an outside voice and an inside voice. The outside voice was very firm to say, we have the right to determine who should be on these pay lists, and it is under our discretion. We go to the next slide.
Which is, I didn't hear you say.
Sorry, I just had to type it.
Certainly. Thank you very much. Go ahead.
Ms. Jones, before we go to the next slide, you made reference to this document to Mr. Hogg. If we could pull up JB tab 2987, which is tab 120 in the demonstratives compendium. You didn't reference here. I don't know if you know who was the author of the document to Mr. Hogg.
This is the Secretary of the Department of Indian Affairs, who again is the most senior, one of the most senior officials in the department.
Do we have the name?
Let's see, we go down to the bottom.
Sorry, can you tell me what that tab is again, please?
For your compendium, Your Honor, it was tab 120.
Volume 4, possibly? Thank you.
Okay, so this is Mr. J.D. McLean, who is signing as the acting secretary at this time. You'll become familiar with his name over time. And this is his, this letter is his, essentially his encapsulation to council of what the Department of Indian Affairs position is on these pay lists.
And this one is a typed version, it appears. Can you just direct us to where we'd find the reference here? I think it's, if you, this is the reference you've identified in the slide.
Yes, there's a highlighted portion there.
I just wanted to make sure I gave the right reference to you, Your Honor. I think it's page 5 of your compendium document. The first full paragraph.
Is that the numbered page 5?
The Superintendent General of Indian Affairs is and always has been the sole authority to decide who are Indians. Now, this means, of course, people, it's a little bit of a circular argument. Who are Indians in the eyes of the department? In other words, who would have a legal entitlement to certain rights and disabilities under various iterations of the Indian Act and the treaties, entitled to participate in the annuities.
Just so you know, it's pretty much
illegible. to me.
Yes, that I have to say the digital copies are much easier to read if you can
Okay.
manage with those. I found that the process of the OCR and the scan and the photocopy has rendered a number of these documents pretty much illegible.
If you're saying the electronic document that I have before me is pretty much easier to read,
It's easier probably than what you have in paper.
Go
Okay.
back to the demonstratives, please. And over to slide 93.
that's just a guide to you, Ms. Glasser. You don't need to send me to a document that I won't be able to read.
I understand. Thank you.
So again, in preparation for another hearing on Robinson Treaty issues, Council for Canada and Ontario developed an agreement on questions to submit to the arbitrators. Including, is the claim of the Dominion on behalf of the Indians since July 1st, 1867, a debt or liability of the late province of Canada? Is it to be included in the excess of debt under section 112? They asked for direction on allowable categories of deductions from revenue to determine if and when an increased annuity would be payable. They asked for the definition of an Indian. What is the proper and legal definition or status of an Indian? To entitle such Indian to participate in any annuities payable under the treaties. And again, Canada thought they had the answer to this. So I think this is at Ontario's insistence. They have their own information about payments to Robinson Treaty beneficiaries, which they think puts them on a very strong footing to challenge who is being paid under the treaties. And also then the number of Indians entitled to annuities, and particularly to the increase. And again, Ontario is falling back on the number of people mentioned in the original treaty. And I would strongly suspect this is Ontario's question, would the increase, whatever it might amount to, be payable only to the extent of the number of Indians mentioned in the treaties?
Had anyone within Canada's department at any time also shared that view?
Well, the memorandum of Sprague that you might remember that had been sent to Ontario in 1873, 4, sorry, attached to the order in council, did express the opinion of Mr. Sprague at the time that the number of people who could be paid annuities was limited to the number mentioned in the treaty.
And do you know whether that had been shared with Ontario?
Yes, that particular memorandum was sent to Ontario.
Slide 94.
These questions put to the arbitrators then resulted in the 10th award, what's called the 10th award. Now there's an award of the 7th of January, 1898 and an order. So we'll deal with the award first. They're two separate documents with the same date. The award is that the contingent obligation to pay the increased annuities mentioned in the Robinson treaties and the arrears of such increased annuities between the years 1867 and 73, and the sums paid by the Dominion in respect of such increased annuities up to the 31st of December, 1892, should be taken into account in ascertaining the debt of the province of Canada. So their ruling then was that both the payments already made and any arrears that might still be owing after 1867 should be added to the debt of the province of Canada. And they did state at that time that they were proceeding upon their view of a disputed question of law. That the contingent obligation devolving upon the Dominion to pay the increased annuities shall be taken into account and included in such debt. So the Dominion still has the contingent obligation, but the amount owing is going to be added to the debt of the province of Canada, which means that Ontario and Quebec will be paying 5% on that amount.
Slide 95.
So then in a separate document dated the same day, we have orders of the Board of Arbitrators of the 7th of January, 1898. And these are meant to give direction to the parties on how to come to a common understanding of the facts of whether or not an annuity should be paid and to how many people. There had been a question about on whom fell the burden of proof to show that people receiving Robinson Treaty annuities were being appropriately paid. In other words, whether or not those people should be included on the pay lists. The burden of proof was determined to be for any additions on the Indians or for those who act for them to be removed from a pay list. The burden of proof was for good reason as shown by those whose interest it is to keep the numbers down. You can read Canada for the first and Ontario for the second. And after Confederation, the arbitrators stated that Ontario and Quebec would not be precluded by the action of the Parliament or the Government of Canada in prescribing a definition of who is an Indian for adding to the lists, adding anybody to the lists. So essentially, the arbitrators are going outside the existing Indian Acts or any other legislation by Canada and substituting their own definition of an Indian, which follows. They say that an Indian entitled to these Robinson Treaty annuities is a British subject resident in Canada, follows the tribal life, any member of any tribe or band who are parties to the treaty, and any lawful descendant of Indian blood, any person intermarried with any such member, and any lawful descendant, any person adopted and acknowledged prior to 1893 by any such lawful tribe or band. And the descendants must be of at least 1/4 Indian blood. And it should be observed at this time that there was no blood quantum requirement in the Indian Acts in Canada. There were other criteria affecting whether or not someone was legally considered an Indian, but not blood quantum.
Could you go back, please, to the burden of proof?
Yes.
What do you say it is? Well, first of all, what's it, the burden of proof for? To be added to the list or to be taken off?
This is supposing that Ontario and Canada get to a point where they are examining the names
list.
in every pay list.
Okay,
So if a party wants to remove someone from a pay list, then they have to prove for good reasons. And the good reasons are not really specified.
so proof of good reasons.
Right. If a party wishes to add people to the pay list, then they have to prove their eligibility. It says that burden of proof rests on the Indians or for those who act for them.
But the burden is to prove what again?
To prove eligibility to receive Robinson Treaty annuities.
Thank you.
So these two clauses, orders read together, again, would essentially open up all of the Robinson Treaty pay lists to a person by person examination and would go outside the existing Indian Act legislation, set different criteria, and possibly also set aside some of the historical relationships that had brought people onto pay lists over time.
You can turn to slide 96.
The board also ordered, these are, again, the order of the Board of Arbitrators, made an order on the classes of expenditure to be taken into account in determining if augmentations of annuities can be paid without incurring loss. This list is pretty similar to the list submitted by Ontario earlier. It's 14 classes of expenditure by the province of Canada, Canada and Ontario, so before and after Confederation. And as well, the arbitrators provided, they call it reasons for the award, but in fact, it is their opinions on the meaning of the terms debt and liability in the British North America Act. So all of these documents have the same date or close, the orders and the award. And again, then the reasons provide further direction to the parties on what their view of the meaning of the terms debt and liability in the British North America Act is. I think a reasonable summary of the reasons, all three of them, is that the terms were used interchangeably. So here in these, the orders and the reasons and the award, they have provided direction to the parties on how to proceed next with this arbitration.
Before you move on to your last point, Ms. Jones, you referred to the classes of expenditures. You referred to 14.
Right.
That was part of the order of the board.
Yes, this is an order.
And can you describe what the classes were?
Well, I think it might be worth just taking a quick look at these classes.
That's at your reference JB tab 2591. And in the demonstratives compendium tab 119. You've identified images 6 to 7 on the PDF of that JBD
Right.
number, which is also page 6 in the compendium of demonstratives.
So these are this is the arbitrator's order as to which types of expenditures and charges were going to be allowable. And we see things like surveys, the costs related to the construction of colonization roads, fire ranging and bush ranging, which is large, it's related to the protection of timber, fisheries protection, expenses of agency, which could refer to either land sales, or that's mostly what it refers to. It could also refer to timber, collection of timber revenues, departmental expenses of collection and management, the geological survey, the construction of locks, dams, timber slides, harbors and lighthouses, roads and bridges. You'll see that some of these are pertaining to expenditures that would have been made by Canada. Most of them would have been made by Ontario.
When
Postal,
you say Canada in this answer, are you talking about the Dominion?
yes. So for example, postal expenditure would have been expenditure by Canada, the Dominion.
Mr. Shacker?
I'm sorry, I rise on a matter of relevance. Again, this list here is a matter of res judicata in terms of the court having already ruled that whatever was decided by the arbitrators does not bind the court in terms of what categories of expenses are and are not helpful to the court as to what was decided. Now, I understand that my friend's earlier questions deal to the witness dealing with respective liability as between the crowns maybe made some sense with respect to other issues, but with respect to the categories of expenses, I do not believe any of the pleadings identify and say that there can be one set of categories of expenses for Canada as between Canada and Ontario, and a different set as between the plaintiffs and the crowns. So I'm struggling to understand how it could possibly be relevant to go through the determination of what the categories of expenses were in the arbitrations, if it's of no help to the court. So I'm a little bit confused on relevancy.
Thank you. Ms. Glasser, I don't, as far as I know, there are no issues before this court on the crown allocation issue where there's to be a determination of what our expenses. And so just because the evidence is here, we don't need it read through because it is certainly not relevant on the issues as between the crowns and the plaintiffs.
Your Honor, this decision here and the information reflected here is relevant to the interactions between the crowns in deciding a debt.
I don't know what interactions mean.
Well, as you've heard from Ms. Jones, the parties are attending before the arbitrators to determine outstanding accounts. And this is one of the parts of the order as it concerned the arbitrations that was provided to the crowns in determining their debts as allocated between them and how they would go about determining them.
Right.
And that is the purpose for which this information is being provided.
The purpose, tell me again the purpose, just because it was determined. What's your link to the purpose for your case?
Well, the decision is relevant and was the guidance.
Not a decision. This list of expenses.
It was part of the decision,
Okay,
which guided the parties in determining the expenses and revenues that would be considered when determining the debt as between them.
okay. And do you say that this court in this proceeding is going to do anything with that list?
Well, as it pertains to the settling of debt between the crowns, I would say that it's relevant.
And you've challenged that?
As between the crowns?
Yeah, Ontario has challenged this?
I don't understand what you mean by challenge.
Well, you're challenging this list, or you're saying that this list is binding, or you're saying that this list should be taken into account now in determining the debt between Ontario and Canada?
This is relevant historical information from the arbitration at that time, which guided the parties.
Okay. I don't actually see how it's relevant to this case. It may, what I want to say to you, just because it's here, we don't have to read it in.
I appreciate that, but Ontario does take the position that the information was relevant at the time with respect to that decision of the arbitrators in the interactions between the Crown subsequent to the decision.
Then we have the document,
Sure.
but it doesn't need to be read in. I'll hear from you obviously at the end about how this might come into play, but it's not obvious.
Okay.
Go ahead.
I might just point out that the payment of the annuities is part of the expenses, as well as the salaries and expenses of Indian agents and superintendents.
That might be relevant.
Okay, we can leave this document then and go back to slide 96. I think, I'm not sure if you had finished the slide.
Yes, I think that looking at the classes of expenditures was more, from my point of view, illustrative. Because eventually there were determinations made, again, at the time, under this arbitration process, about in what years an increase was payable. So where did they get this idea? How did they come to that? And it arises mostly from the orders of the board. So in February of 1898, Quebec filed an appeal to the Supreme Court of the 10th award. So again, not the orders, but the award itself. Quebec's argument was essentially that it should not be responsible for any part of the annuities. But that appeal was dismissed in October of 1898.
Slide 97.
So after receiving this direction in the orders, both Canada and Ontario went back to work on assembling their data. And again, Counsel for Ontario objected to the number of people paid annuity by Canada, stating that the Dominion has doubled the original number of annuitants and their pay lists are now to be scrutinized. So under pressure, I think, from Ontario, Canada continued its investigations into the Robinson Treaty pay lists, instructing their senior official undertaking the investigations to make his reports consistent with the order of the Board of Arbitrators on the definition of an Indian and who would be entitled to the annuity. But that senior official, Mr. McRae, refused. He told his superiors in the department that the definition as given by the Board of Arbitration would, in his words, embrace many persons who by law and by past rulings of this department are not and have not been regarded as Indians or annuitants. Whilst if a narrow construction be put on the same terms, numbers whose right to the annuity has been recognized without question would become disentitled. The lists would no longer represent the Indians. So he's advising the department that using this definition from the arbitrators would essentially turn all their pay lists upside down. They would end up including people who had never been included and excluding people who had always been included. I might also make the point at this stage that being included on a treaty annuity pay list had implications, not just for who might receive $4, but could also determine other treaty entitlements, as these pay lists were used by the department at the time. For example, to reside on an Indian reserve, it could affect where children went to school. It could affect the recognition of harvesting rights within the territory. There were a lot of things tied up in these pay lists, more than $4. In the very constitution of the communities along the Huron and Superior territories, was essentially, at least in the vision of the department, being challenged.
So what we have is a civil servant refusing. to-
Yes. He says, we can't follow this order because it will completely turn our pay lists upside down. If we have to challenge every single person on those pay lists and try to subject them to these outside criterion, we, our own process is completely disrupted, which has, in this part, been in evolution for over 50 years.
Your Honor, it's just after 4, which is when I plan to conclude today.
Just good time for it.
Yes.
Thank you. Okay. So we'll start again tomorrow at 10. We don't have many days left, but we won't start at 9 if we're going to end at 4. So we'll go tomorrow. You think you will go past the lunch hour? Possibly. Okay. And then is anyone besides Canada cross-examining?
Yes,
And we,
briefly, I would expect to be about an hour.
and will you go before Canada?
No, I would.
And Mr. Bass, you're up.
Yes, I also anticipate a cross-examination. It would be a brief one in the range of 10 to 15 minutes, most
All right.
likely.
And you'll follow Mr. Schachter then?
That has been the usual practice. And that would
Okay,
be our
so it is
expectation.
likely then it will break tomorrow after you're finished your examination in chief, Ms. Glasser, and wait for Ms. Evans' return on Monday. And Monday, so we don't know how long Canada will be, but so we'll do all the cross examinations and then we will convene for a case management meeting. Is that the plan?
I believe Canada has advised earlier that they are expecting to be around an hour.
It will not.
This is what Ms. Evans advised.
I was just gonna say, it's easier for you to say that.
Easier for me to say.
Okay, very good. We'll break. Thank you all until tomorrow.
All right.
Oyez, 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 the sittings of this court have now concluded. Long live the king.